How do you think we ought to deal with the mixture issue?
Well, I think the fact that it originated, that the monument originated by the Eagles, a third party, doesn't in any way take away from the fact that in this particular case, and in most cases involving donated monuments, which, as the United States will point to, most of the monuments in parks are originated with third parties.
Well, they probably are, but most of them, and you correct me if I'm wrong here, but I don't suppose that most of them contain as part of in a prominent place in the monument itself, contain the statement that this is the gift of, or the position of, or whatnot of X, Y, or Z, whereas this monument does.
Most of them, Justice Souter, do actually have statements. In fact, a perfect example would be at Gettysburg National Military Park. A number of those monuments, most of them, are donated and originated by third parties. It'll often say donated by, for instance, the Father Corby.
We may have more cases coming than I
hope not.
But tell me, what is the criterion that we should use to decide what the significance of the private identification is?
I think the key should be, as this court alluded to in Johans, the issue of control. Who controls the message ultimately here? And the fact is, the Statue of Liberty, originated by the Franco-American Union, was originated by a third party. The United States, by resolution, accepted it. At that point, title transferred.
But if we accept that there is government speech, I think Justice Souter's question is, isn't this really the government endorsement of the Eagles' message? I mean, the Eagles are all over this monument. They're a symbol of the eagle, and the Eagles want it to be known that this is their monument. Indeed, I think in Van Orden, in the district court there, wasn't the statement, well, the Texas did this in recognition of the good work that the Eagles do in trying to prevent juvenile delinquency.
Yeah, and I think that actually points to why that once it's controlled and owned by the government, the fact that it originated in a third party, Justice Ginsburg, changes the equation for ownership and control to the government.
But if it does, it changes it, as I understand your answer, by eliminating the private aspect of the speech, so that your real answer to me is it's not a mixture, and it's not. It ceases to be a mixture the moment the government accepts it.
Once right title and interest vest under Utah law in Pleasant Grove City upon acceptance, and at that point it is owned and controlled by the city. And the fact that it was originally created, and Justice Ginsburg, you're correct, the district court and also the Court of Appeals in Van Orden stated that it was originated as a moral guidance for youth. That was the reason that the Fraternal Order of Eagles developed it. The state of Texas said, we're going to honor the Eagles. That was their reason, as well as showing the role of the Ten Commandments and the rule of law. And then excuse me, Justice Stevens.
Can I answer a question that's kind of in the background
Sure.
of the case? Assume you didn't have the policy that you do have, but it was perfectly clear that the city decided not to put up this monument because it disagreed with the message in the monument. And whether you call it government speech or private speech, would that be permissible?
No, it wouldn't be a First Amendment free speech claim. It might raise an Establishment Clause, equal protection kind of clause analysis case, but not under the basis upon which respondents have sought here. And I think that's important to point out. The basis upon which they sought access, if you will, is a species of an equal access claim. But of course, our position, the government hasn't established anything by accepting the monument.
But it seems to me Justice Stevens' question is important, maybe not for your case, but for other cases. We're deciding this for other cases to arise. And why isn't he correct? That if you don't like the message, then that raises a content-based claim.
Because if the government's speaking, if it's the government's message, they're of course allowed to engage in content-based statements. The Statue of Liberty was a statement of liberty enlightening the world. I could go give a list of monuments that do that. I mean,
I understand.
That's what they did.
It doesn't seem to me that you have to make the government speech argument for you to make the argument you just made.
No, not necessarily, because even under the speech selection cases, I mean, that's correct. Governments make determinations of what they're going to put in their parts to communicate a message. That's very different from a situation, I think, where the 10th Circuit panel was incorrect and respondents are incorrect. They confuse the issue of the government actually creating a forum or a venue for speech, and that perfect example of that would be here with ownership and control vesting in the city. Very